Let me then take you directly to a rather dramatic development in the United Kingdom in the last 2 weeks. It concerns a case that has been wending its way through the English courts, the case brought on behalf of a British resident at Guantanamo, Binyam Mohammed. Binyam Mohammed is a resident of the United Kingdom, not a national. He is a detainee at Guantanamo. He has alleged that he was apprehended in Pakistan. He was then taken to Morocco, where he alleges he was tortured, and he was then transported to Guantanamo. He was then charged before the military commissions procedure. His lawyers sought access to evidence that would have tended to provide support, one way or another, for his allegations as to torture, which goes to the question of the admissibility of the evidence on which those charges were based and whether it could be relied upon. Under the military commission procedures, the position was that he would not gain access to that material through normal discovery processes until the proceedings were underway, which would of course mean he would have no possibility for gaining access in time for him to use the material in any sort of meaningful sense. So what his US lawyers decided to do was bring proceedings in the English courts on the hope that perhaps the British authorities might have some of this same material available in their files. And he sued the Foreign Secretary, David Miliband. He retained a team of 3 lawyers. I'm one of those 3 lawyers. I have a bit part role because my role is limited to the public international law side. And lo and behold, in the course of those proceedings, the British government accepted that it may have documents which had been made available to it from the United States, which may tend to show that he was subject to cruel, inhuman and degrading treatment, and that his level of treatment may indeed have crossed the line into torture. The British government has accepted that. And it has accepted also that its own intelligence officers, and we're dealing here not with military interrogations, but intelligence officers and CIA, were present in Pakistan. 2 British intelligence officers were cross-examined in the court proceedings in July and August of this year. And they were cross-examined in the context of open and closed proceedings. I'm very interested in this conversation about security courts. We don't have security courts. We have things called special immigration appeals courts, which hold closed hearings which neither I nor the defendant are entitled to have access to intelligence information in relation to. In the course of those cross-examinations, the evidence emerged which showed so clearly that the British had knowledge of cruel, inhuman, degrading treatment and possibly torture, that the 2 judges, deeply conservative judges, I would say, 1 Court of Appeal judge, 1 High Court judge, immediately stopped the proceedings, advised the intelligence official of his right against self-incrimination, since it appeared that the evidence showed he had been involved in criminal activity or may have been involved in criminal activity, and invited him with immediate effect to get his own criminal defense counsel. The rest of the cross-examination took place in closed hearings. I've not seen the material from the closed hearings, but a judgment then emerged in September of this year in which the judges gave an open and closed judgment, and in the closed judgment, material was passed on to the Home Secretary, our equivalent of Homeland Security, Michael Chertoff. 10 days ago, the Home Secretary wrote to the Attorney General, acting in her capacity of Minister of Justice, and ordered her to commence a criminal investigation in relation to the acts of British and American intelligence officers on the basis of material in these proceedings which tended to show that torture may have occurred. Since torture was an international crime, the United Kingdom was under a legal obligation to fully investigate the circumstances of those crimes. That criminal investigation will now begin, both of the British and the American side. It will not be limited to the interrogators. Necessarily, it will have to address the question, did the interrogators act on instructions? Where did those instructions come from? Who signed off on the techniques or on the decisions that were used, and how high up did it go? And you can begin to see where I'm going with this. What has emerged in the past 6 months is that the President of the United States himself, Commander-in-Chief, for many of the people in this room, Apparently, well, he has owned up to the fact that he signed off on these techniques of interrogation. And this puts the British authorities, frankly, in a very, very difficult position, because it appears that the British criminal investigating authorities are, in the coming weeks and months, to have to deal with the difficult and delicate task of investigating criminally decisions that would have been taken in Britain, in the United States, in Pakistan, and elsewhere. So to wrap up, this is not a hypothetical situation, I say with great regret. It is a real situation, and it's not a situation which the United States is going to be able to control for itself by reference to any immunity purportedly granted in the Military Commissions Act, or even by any presidential pardons. And let me just end by making this point. The idea that the United States, the rule of law country, primus inter pares, the most important country in the world for promoting the rule of law, could countenance a situation in which its president could give a pardon for the commission of an international crime, would send a signal that, with great respect, would be enormously damaging for the reputation of this country. I sincerely hope that it doesn't happen, but if it were to happen, it must be understood that that pardon could have no consequences outside the territory of the United States, and would undoubtedly have the consequences of making further criminal investigations abroad more rather than less likely. Thank you.
Yesterday I said that we're at a pivotal moment in legal history. I think this is one of the most significant moments that we'll see in our lifetime. I think that the future is international, and I'm going to speak about the international justice movement, and in particular the Rome Statute framework and the International Criminal Court. I'm going to speak briefly because we've all been sitting for a long time and I want to open the discussion. The International Criminal Court, there's three ways to start a case: a state referral, a Security Council referral, or the prosecutor proceeding proprio motu, on his own power, making a request to the pretrial chamber to start a case. The court has no jurisdiction over a case. It's been prosecuted already in a member state or in its own state. What this means is that the International Criminal Court, court of last resort. There's been a lot of misunderstanding about what this court is going to do, that it's going to reach in, violate sovereignty. Actually, the court was designed in order to buttress sovereignty. So what happens here is that states that sign on to the statute, that's 106 states to date, make a commitment to prosecute 3 crimes: genocide, war crimes, crimes against humanity, and the latent crime of aggression, which is not yet defined, which I spoke about a little bit yesterday, and potentially other crimes will be added. But for now, these states have agreed to prosecute only 3 crimes. The agreement is that if they do not, because they're unwilling or unable to proceed, go ahead with the prosecutions, then the International Criminal Court can proceed. So this is not going to be the monster that reaches in and takes over and destroys the democratic process and that kind of thing.